This is Duke University.
The program in public law here at Duke Law School. Today's event is the Constitutional Challenges to the Patient Protection and Affordable Care Act, a statute you are no doubt familiar with, and I will refer to as the ACA. So the end of March 26, 27, and 28, the court is going to hear many hours of argument in the present challenges to various aspects of the statute. I'm going to briefly identify the 4 questions presented that the court is going to consider, and then I'm going to turn it over to my colleagues who are going to share with you their views on what the court should do, what the court will do, whether it and how much it matters, whatever the court does. They'll speak for about 10 minutes each, and then that should give us plenty of time for conversation, for questions and answers. With me today, I'm honored to say, we have Professor Maggie Lemos, who recently joined the Duke Law faculty. She is a former Bristol Fellow in the Office of the Solicitor General at the Justice Department. She's also a former law clerk to Justice John Paul Stevens, and I think she's going to predict with certainty how he's going to vote in this case. Next to Maggie, we have Professor Stephen Sachs, who also recently joined the faculty. He is a former law clerk to Chief Justice John Roberts, and I doubt he's going to be predicting with certainty how the Chief is going to vote in these cases. And then at the end of the table, I'm very pleased that we have with us Professor Richmond, who is not a new member of the faculty, but he is an expert in, among other things, healthcare law and policy. And so I have a feeling he's going to put into perspective for us what's at stake in the long term, regardless of how the court decides these challenges. Okay, so what are the questions that the court is going to hear? There are 4 of them. First is whether the Federal Tax Anti-Injunction Act bars the present challenges to the minimum coverage provision in the statute. This is a federal law that goes back to the 1860s, which bars any lawsuit that has the purpose of restraining the assessment or collection of any federal tax. And the question is whether the minimum coverage provision and the shared responsibility payment in the statute qualify as a tax for purposes of this law. If it doesn't, the court can then go ahead and hear the merits of the challenges to the so-called individual mandate. If it does, what that means is that you're not going to get a merits ruling from the court at this time. We'll have to wait. We as a legal system, as a political system, will have to wait until 2015 in order for the present challenges to the minimum coverage provision to be resolved. So you have a threshold potential jurisdictional impediment. Right? Does this federal law bar these challenges? The second question presented is the one that's gotten the most attention in the media. This is the challenge to the so-called individual mandate. The statute requires most people lawfully living in this country, applicable individuals, either to obtain a certain basic level of health insurance coverage or else to pay a certain amount of money each year. That amount of money, the exaction for non-insurance in the law, is called the shared responsibility payment. The statute denotes it a penalty. The question of the constitutionality of the minimum coverage provision is really 3 questions. Right? Congress, as you know from first-year con law, needs a hook to hang its regulatory hat on. Is the minimum coverage provision within the scope of the tax power? Clause 1 of Article 1, Section 8, which gives Congress the power to lay and collect taxes to pay the debts and provide for the common defense and general welfare of the United States. Is the minimum coverage provision within the scope of the 3rd clause of Article 1, Section 8, the Commerce Clause, which gives Congress the power to regulate commerce among the several states? Is the minimum coverage provision within the sweeping clause, the necessary and proper clause, the 18th and last clause of Article 1, Section 8, which gives Congress powers to pass laws that are necessary and proper to carrying into execution here the Commerce Clause? If the government wins on any of those issues, it wins on the minimum coverage portion of the suit. The government needs just one clause. Those challenging the provision need to win on all 3. They need to argue, they need to convince the court, 5 justices, that there's no provision within Article 1, Section 8 that justifies the minimum coverage provision. A 3rd question in the case concerns severability, a question of statutory interpretation. If the court upholds the minimum coverage provision, it doesn't reach severability. It struck nothing down. If the court invalidates the minimum coverage provision as beyond the scope of federal power, then the question is, does the rest of the statute also get invalidated? Does none of the statute get invalidated, the rest of it remains, or does some of it get invalidated and is some of it upheld? Of particular interest are some very popular portions of the ACA, the guaranteed access provisions, the provisions that prohibit insurance companies from denying people coverage based on pre-existing conditions, that prohibit insurance companies from discriminating against people based on medical history, imposing lifetime limits on coverage, canceling insurance, absent fraud. The government itself argues that if you strike down the minimum coverage provision, you've got to strike down those provisions as well, because you put insurance companies in a financially untenable position if you deny them all the ways they've classically used to control costs, right? And yet at the same time allow people to wait until they're sick to get insurance. If you do that, the government argues, the insurance companies argue vociferously, you don't have health insurance anymore. What you have is an entitlement to care in the event a risk materializes. Insurance is a hedge against future risk. If you have these provisions that guarantee access without requiring people to get insurance ahead of time, the government argues, you no longer have insurance. You have insurance companies who can't financially deal with the situation. So there's a question of severability. What follows if the minimum coverage provision is struck down? And then finally, you have its own major constitutional question, the constitutionality of the Medicaid expansion in the statute. There is a very significant expansion of Medicaid eligibility. Now everyone is not otherwise eligible who falls below 138% of the federal poverty level is now newly going to be eligible for Medicaid. And what is more, the government, Congress, didn't condition the additional federal funding on agreeing to these new conditions, expanding access to Medicaid. It made all federal funding under Medicaid at stake, right? And so if a state disagrees to expand Medicaid eligibility in the way the statute suggests, then the Secretary of HHS has the discretion to deny the state all federal Medicaid funding, and a huge part of each state's yearly budget. The constitutional question concerns the conditional spending power under a 1987 decision, South Dakota versus Dole, in which the court held that Congress could attach conditions to federal funds, even if Congress can't regulate the matter directly, but the court said there may be a point at which an inducement or an encouragement, an incentive becomes so great, such a temptation, that it's coercive. It's unconstitutionally coercive. It's as if the federal government is requiring the states to do something because the states just can't say no. The court has not put any teeth into the coercion requirement. It has not struck down a single conditional federal expenditure as beyond the scope of Congress's power, as unconstitutionally coercive. Will it do it for the first time here? So those are the four questions presented in the case. Let me now turn it over to my colleagues who are going to tell you everything you ever wanted to know and more about this litigation. Maggie Lemos.
So I'm actually not going to tell you anything useful about the four questions that Neil described, because I don't want to, preview how Justice Stevens will decide the case. Instead, I want to talk about something else, which is the really interesting intrastate divisions that have been aired through these cases and these challenges. So, for example, you may know in North Carolina, the North Carolina General Assembly passed a statute that basically made it illegal for North Carolina to comply with the ACA, and that also purported to require the North Carolina Attorney General to challenge the ACA. The North Carolina Attorney General issued a written opinion saying this law is bogus, this law violates the Supremacy Clause, and then the North Carolina governor vetoed it. And so in here, the dispute didn't really come to a head because you had governor and AG on the same side. But in lots of other states, the governors and attorneys general, who in most states are separately elected and so maybe from separate parties, have disagreed. So just a couple of examples. In Washington, for example, Washington State, the Attorney General filed a challenge to the ACA over the governor's objection. The governor then filed an amicus brief defending the ACA. And so you have, the Attorney General speaking on behalf of the state of Washington saying this statute violates, our rights as states, and the governor saying, no, it doesn't. We actually really like this statute. In Nevada, the politics went the other way with an interesting twist. And so in Nevada, as in some other states, the governor instructed the Attorney General to file a challenge to the act, and the Attorney General said no. What was different about Nevada is that the governor then went out and found a private attorney who was willing to represent the state for free. And so Nevada was able to join the challenges with someone other than the Attorney General at the helm, this private attorney from Las Vegas. The governor also set up an outside fund to collect money to fund the litigation, because although this attorney was willing to work for free, there would be other costs associated with it. And then the Attorney General said publicly that all of this violated Nevada law. This question of outside funding for state litigation goes beyond the fund in Nevada. As you may know, Florida is really spearheading, or has been spearheading much of the state litigation. About a year ago, the Florida Attorney General told the Florida legislature that virtually all of the state's legal costs were being covered by a private group, the National Federation of Independent Businesses, which is also a private plaintiff in Florida's suit. And so you have the same outside counsel representing the private plaintiff and the state plaintiffs, but the twist is that the private group is covering virtually all of the state's legal costs. We don't know how much it is, but as of a year ago, when Pam Bondi made this statement to the Florida legislature, the case had already gone through the district court level, so lots of lawyer work had been done, sort of cashing out the original arguments. And at that point, Florida had paid less than $6,000 for their attorney's fees. So we were talking about a lot of money being supplied by the outside group. And that's particularly interesting in light of the fact that lots of the other states that have joined Florida's litigation have statements on their websites and the like saying, you know, this is great, we're able to join this litigation, but our taxpayers don't have to foot the bill because Florida is really footing the bill for this litigation, except it turns out that Florida is not footing the bill for the litigation. This question of outside funding for state litigation is by no means limited to the ACA. It's getting more and more common. And so, for example, you probably know that Arizona is embroiled in quite a lot of litigation right now defending its immigration laws. Much of that litigation is being funded by private sources as well, because they have set up a defense fund that's stocked by private sources to fund that litigation. There are very interesting questions of transparency here, I think. These debates between state actors that I've been describing raise questions about who speaks for the state. Those questions will probably be only answerable through the ballot box. It's unlikely that you're going to get a lot of courts resolving these disputes between governors and AGs. But it would be nice, right, if voters could know what's happening, that if voters could assess who's funding and who may be driving litigation that's filed in their names. So all of this stuff is interesting at a theoretical level, but it also ties into a question that's lurking in the back of these cases, although the court has not granted cert on it, and that's the question of the state's standing, whether states have standing to raise these challenges to the ACA. That question was posed most squarely in the Virginia case, and the court did not grant cert on that, suggesting, understandably, that the court does not want to have to grapple with that question. It could still come up, though. I think it's quite unlikely, but it could still come up because of the Anti-Injunction Act issue. So if the court concludes that the Anti-Injunction Act does bar the challenges, it will then have to decide whether that act applies to states. It would on the theory that states are persons within the meaning of the Anti-Injunction Act, and states generally are thought to be persons under federal laws that use that term. But if the court concluded that the Anti-Injunction Act bars the challenge and states are not persons, it would then have to figure out whether states have standing to bring the action. I think it's quite unlikely that that will happen, but it's possible. And these questions of who speaks for the state are relevant to the question of whether the states have standing. The states have some ACA-specific standing arguments. I think the most plausible one is linked to the Medicaid provision that Neil mentioned. The states say that as a practical matter, the individual mandate is going to lead lots and lots and lots and lots of people to take advantage of the Medicaid eligibility, and that will cost states lots and lots and lots of money. The response to this on the Fed side is having folks sign up for a benefit that you're voluntarily offering under state law is not an injury within the meaning of standing doctrine, and who knows how the court would resolve that. The one thing I do want to mention, though, is that the states also have a much larger or broader theory of standing that, if accepted, could have really big implications for federalism. And that has to do with the state's authority to speak on behalf of its citizens, to speak as sort of the master of that collective. States typically do have authority under the doctrine of parens patriae to litigate actions on behalf of their citizens, as long as the citizen interest is sort of large enough. But there is a long-standing, if completely untheorized, exception to that doctrine for challenges to federal law, for challenges where a state tries to accept its citizens from the operation of federal law. Now, the idea behind the exception is that if we're talking about the relationship between citizens and the federal government, then the relevant parent, for parents patriae purposes, is the federal government, not the states. And so, the idea is don't go meddling in our relationship. And the state's response to this, I think, has some bite. It is, that's crazy, at least as applied to enumerated powers challenges. And so where the crux of the entire claim is that the federal government has overstepped its bounds vis-a-vis the states, who better, the states say, to litigate those actions than the states themselves? This argument is very similar, although not exactly the same as the arguments that were made in the Virginia case and that the Fourth Circuit considered and rejected. And one of the reasons why the Fourth Circuit rejected them was because allowing states standing on this theory or anything like it would allow the states to become roving constitutional watchdogs in the Fourth Circuit's term. And again, the state's response was, well, so what, right? Why would that be so bad to have states as constitutional watchdogs? And so these standing questions raise, I think, or could raise deep theoretical questions about federalism and who federalism is supposed to protect, right? Is federalism there to protect the states as states? Or are the limits on federal power a means to the broader end of protecting all of us as citizens through the mechanism of dispersed power? I mean, that's one way you could try to get at these questions of whether we want states to be constitutional watchdogs. You might also think about it in more sort of simple standing terms, right? Thinking about the principles that lie behind standing doctrine. What is standing doctrine concerned about, and how does it play out here? And this is where I think the intrastate battles and the questions of funding might become relevant in a legal sense. So let me just give you one example of that. One of the things that standing doctrine is worried about is opening the floodgates of litigation, right? We make sure that the only people who are allowed to sue are people who have a real stake in the case, in part because we worry that allowing people to sue about generalized grievances and the like would just lead to millions and millions of lawsuits by meddlesome people who don't really have a stake in the game, but who are upset in some way about federal law. Understood in those terms, you might actually really care about who's paying for this stuff, because states have sharply limited resources, particularly right now. And so, if states have to foot the bill, then even if we say, okay, fine, states, you can go be constitutional watchdogs, as a practical matter, they're just not going to be able to do that much. It's not going to open the floodgates of litigation. But if states are able to accept funds from any private person who wants to fund it, then the Fourth Circuit's concern about opening the floodgates becomes a lot more real as a practical matter. And so this is just a little example of how these sort of broad constitutional theories have important links to kind of secret hidden stuff that happens at the state level about who exactly it is that's speaking for the state and who exactly is sort of driving that speech. I will stop talking.
Thank you very much, Professor Lemos. And now we're going to hear from Professor Stephen Sachs.
So I also will not be speaking about all four of the questions the court has granted cert on. I won't say anything about the Anti-Injunction Act, about state standing, or about the Medicaid expansion. I will talk primarily about the merits and just a little bit about severability at the end. One of the things that's been interesting to see over the course of this litigation is how the issues that are at stake have evolved over time. I think that a lot of the early attention on this case came in the form of attention to the Commerce Clause question. Under the Commerce Clause, Congress can regulate a variety of things. They can regulate, persons or things in interstate commerce. They can regulate the instrumentalities and channels of interstate commerce, and they can also regulate other kinds of things that have substantial effects on interstate commerce in the aggregate. Now, in two cases in the 90s, and in 2000, Lopez and Morrison, the court clarified that only economic activities, not just anything in the world, such as having a gun in a school zone, that has a substantial aggregate economic effect, would qualify for Commerce Clause regulation. And a lot of attention had been paid early on to the question of whether the mandate fit in this pigeonhole. Is the state of existing as an American without health insurance an economic activity, or is it inactivity? And sort of a lot of weight was put on that distinction, trying to argue that this falls outside Congress's power. On the other hand, people would argue that no, this is perfectly within Congress's power because the people who aren't buying insurance are still using health care, and the cost of that health care is borne by somebody else, and that activity is what Congress is really going after here. The two arguments that got less attention were the necessary and proper argument and the tax argument. The first being that the individual mandate is there to support other regulations that clearly fall within Congress's Commerce Clause powers, at least under existing doctrine. And the other being that the mandate and the penalty attached for failing to meet the mandate are really one and the same thing, and they're both just a means of raising revenue from people who don't pay it already in the form of insurance premium. In particular, I think the necessary and proper clause argument got short shrift for a long time. And this is really interesting because one of the sort of simplest defenses of the individual mandate is as a necessary and proper measure. And the Affordable Care Act does a number of things, such as the guaranteed issue provision that says that insurance companies have to be willing to extend you insurance even if you have a pre-existing condition, even if you're already sick. And moreover, a community rating provision, which says the price they charge you for that insurance has to be the average price that sort of everybody pays in your area, not a higher price because you're already sick and need an operation tomorrow, and so by buying that insurance, they already know they have to pay out a large amount of money. So the community rating provision, I think, got some of the least attention in terms of how the whole act worked and how the mandate might be necessary and proper to support it. Now I think that's changed. I think that the government in its briefs before the court, and I think that a lot of the public discussion surrounding the act has really started paying a lot more attention to the necessary and proper clause and has put it front and center. I mean, as you guys have probably heard in your legal writing classes, always lead with your strongest argument, and the government leads with many, many pages on the necessary and proper clause. And its argument, follows in the way we've described. It says, look, insurance is the ordinary way of paying for care. This is how Congress chose to deal with a crisis in the healthcare system, was by making sure that everybody had insurance and that people couldn't wait till they got sick to buy insurance or just go to the hospital without insurance and have the hospital and then therefore other people through their insurance premia pay for the cost of their care. And the basic idea is that the individual mandate is necessary to make the rest of the act work. And the government, of course, also makes Commerce Clause arguments and Tax Clause arguments, but I think the real focus is on the necessary and proper clause. What's interesting about the respondents' briefs on that question, the states and the private parties, is that they do talk a lot about the necessary and proper clause, but it's very much tied into their Commerce Clause argument. So the states, for instance, lead with the argument that this isn't a Commerce Clause regulation because you're not regulating commerce. To regulate means to deal with something that's in some sense already out there. When you're regulating commerce, you're sort of telling people you can't do this kind of commerce, so you have to have a license for that kind of commerce, but it's not forcing people to enter commerce the better than to regulate it. They make the analogy that sort of rules for the governance and regulation of the land and naval forces presume the existence of land and naval forces, which other clauses in the Constitution in fact provide. But that one clause wouldn't be enough to generate a standing army if there had been nothing else in there to say that we would have one. Whatever one thinks about that argument, I think that what's interesting is the way that they tie the commerce regulation to the necessary and proper clause. The basic point is, look, the only way you can avoid the long arm of the federal government under today's doctrine is not to engage in the kind of activities that might lead you to be creating a substantial economic effect in the aggregate. And that's precisely the sort of people that the individual mandate is targeting. So if in a given month you don't have health insurance for that month, you may or may not use health care in that month, but the government still cares about whether you've got insurance and whether you're paying it forward. So the idea is the government is going out there and in some intrusive way forcing people who just want to have nothing to do with the things the federal government can regulate to come into the system and therefore be sort of fully regulable in lots of ways. And they argue that this is both a commerce and a necessary proper clause problem in two ways. One is that this is a problem sort of that the government created in its own act, sort of the bootstrapping argument that Stuart Benjamin has written about. That the government, by messing up the insurance industry with all these other laws, now brings in the individual mandate to save the act from destruction. But that's not, government can't sort of assume all the powers it wants to fix the problems that it's just creating. But the second argument, and I think the even more interesting argument, is just a reference to what Chief Justice Marshall in McCulloch talked about, the great substantive and independent powers, the sorts of things that you wouldn't think were just implied or incidental to the other enumerated powers. So an example would be, sure, it might be necessary and proper to have a military to defend the post office if, France invaded. But the fact that there's a post office clause doesn't give Congress the power to set up a military if there weren't also a raise armies clause. So you can't, we're not going to hide elephants in mouse holes. You can't infer these really big, important powers just insofar as they might be necessary to do other things that are more minor or that are just on different topics altogether. And the respondents in their necessary and proper arguments really push this issue that this is just too big a deal for the government to try to sneak in under some other power that it already has. Now, I don't know whether that will succeed in the end, but I think it's a really interesting move. And I think that if it is accepted, that will be one of the bigger sort of takeaways from the case is if the court strikes down the mandate, it will lead to some very interesting jurisprudence later down the road on necessary and proper power. In particular, the analogies are to two cases where the court has already struck down measures of the necessary and proper power, one being Prince versus United States, where the Congress wanted to require state officers to enforce federal laws, and the other New York versus United States, where the Congress was basically ordering the states to pass legislation to deal with certain kinds of problems. And if those things were sort of too important and too big and too threatening to the federal system, does a requirement that sort of absolutely everyone enter the market for a given product and sort of subsidize a private industry qualify as that kind of move? Finally, the last thing I want to say is that if the court does strike down the individual mandate, the severability issue will be a giant mess, just because the Patient Protection and Affordable Care Act, as it was amended by the Reconciliation Act, is huge. It has lots of things. Some things are necessarily tied to the individual mandate in the sense that if the individual mandate is gone, they will nearly immediately bankrupt the insurance industry. Other things are not. Things like, requiring nutrition labeling on certain kinds of food products. I mean, it has something to do with healthcare, which is why it's in there, but it has nothing to do with the individual mandate. And whether the court is going to take the time to sort of slice out things that should or should not fall is anyone's guess. It may well be that they're just going to throw up their hands, say, to heck with this, we're going to invalidate the whole thing and let Congress start over. If they do that, I wonder whether they might do something they did in the Northern Pipeline case and in other cases, which is delay their judgment by 6 months or something. And sort of say, we're not going to say all these other things are already part of the law that people are already complying with disappear tomorrow. We're just going to say that they disappear in 6 months, and hopefully Congress will have thought of something better to do before then.
All right, thank you very much, Professor Sachs. And now we're going to hear from Professor Richmond.
These are always great fun. I especially want to thank Professor Siegel for the exceedingly healthy lunch, which might make actually the need for any of us to purchase insurance less immediate. In exchange, actually, I'm going to answer his questions. His questions were, what do I think the court will do, and what do I think the court should do? And I'm going to go out on a limb here, and I'm going to say the court is going to invoke the Anti-Injunction Act. Say that there is no need to go into the merits here at all. Everybody should go home. And I think, in fact, that's exactly what this court should do. This is a really bad way to make healthcare policy. It's frankly a really bad way to make constitutional policy, I think, also. It's a really bad way to make healthcare policy. There are a number of ironies in why we're spending so much time on all this. One is the following. the healthcare sector in the United States still already consumes about 18% of the GDP. And the federal government has its tentacles in every single part, from extracting somewhere, depending on what your income is, between 3 and 45% of your compensation, of your total compensation, squeezing that out of you, to telling you what kind of aspirin you can and cannot buy at the drugstore. The government's everywhere in that 18%. And the fact that there's a possibility that this legislation would make the government more intrusive in your relationship with this sector, with your own health, I think actually is pretty laughable. And I think actually the Supreme Court's beginning to realize that, which is why it's going to send everybody home. And I don't think anyone's going to come back afterwards in a couple of years, too. In large part because, and this is the second irony, the metaphor I like using is the house is on fire. If the Supreme Court spends its time, if the lawyers of America spend their time trying to figure out whether this is constitutional or not, unbeknownst to them, we're going to become a banana republic in the next 5 to 7 years. Our health care costs are completely unsustainable, both public, this is Medicare, it is bankrupting the government, and the private health care costs, it is bankrupting families and businesses and individuals. And to the degree that this legislation has anything to do with the immediacy of the problem, well, it probably makes it a little worse, actually. But it doesn't address, it neither mitigates the severity of our bankruptcy problems, nor does it do anything, actually it does a couple things to exacerbate it a little bit. So actually, maybe the court should say that this is unconstitutional. We'll get another couple years of solvency. So we'll be a banana republic in 8 years instead of 6 years. That's actually pretty constructive. So on one hand, there is, this is an enormous diversion of resources, I think, from solving what really is our primary domestic problem. And on the other hand, there's an irony that the government is everywhere, and this is this is not Wickard versus Filburn. This is not like some guy making wheat in his backyard. I mean, this is everywhere. And if Wickard is not being challenged here, then it's all the more laughable that this should be challenged. And here's another irony. I was doing some back of the envelope calculations this morning. So as I understand the individual mandate argument, it's that the requirement to have individuals purchase insurance or otherwise experience a tax or a penalty, I guess it would have to be a penalty to make it unconstitutional, is a violation of constitutional freedoms, the sanctity of individual autonomy, personal liberty, however the big brains want to describe it, is laughable in the following reason, for the following reason. I actually think, if you look at the actual provisions, I think that those individuals who really cherish their freedom will actually be more free after PPACA than they currently are. So think about it this way. Right now, the tax code pretty much induces all employers to withhold what is essentially about $8,000. This is usually about 80% of a $10,000 health insurance premium. $8,000 to purchase on the employee's behalf without the employee really having much of a say. I mean, after all, this is a tax inducement. It would be, the employee would be paying taxes on an $8,000. It would be saying goodbye to tax-free money if they were to want to do anything otherwise. Under current law, employers withhold about $8,000 of employee take-home pay to purchase a health care insurance plan that's subject to a whole boatload of both state and federal regulations. So under current law, this is actually a lot more coercive than any state could claim Medicaid is. An individual pretty much is denied personal freedoms to decide what kind of health care plan they want. The tax code makes it impossible, economically impossible to say no, and the regulatory thicket makes it impossible to decide what kind of health plan they want. Under PPACA, employers are going to be offered a pay-or-play provision, which I guess is an excise tax or a penalty, where they do not have to pay for their employees' health care. They instead can pay a tax. And then assuming that the exchanges are reasonably up and running, the employee can then has the option of purchasing health insurance themselves, subject to their own excise tax or penalty. These penalties are really small. I was talking to someone at Duke here. We're saying, look, I mean, we would essentially be paying 1/5 of our current cost for health insurance if we just paid the penalty. And that's even, let's say we, after paying the penalty, we compensate people, we raise their take-home wages a little bit. We're saving a lot of money. This pay or play tax or penalty is actually a gateway to our own freedom, especially since health insurance costs are going higher and higher. Let's just pay the tax, which is really it's $2,000 a year per individual compared to $10,000, $11,000 of an annual premium. We'll just pay the tax and go away. This is great. Thank goodness PPACA allows us to do this. So then the individual is confronted with the choice of purchasing health insurance or paying the tax. And that tax is really low also. It's pennies. So here's an individual after PPACA has the option of not having insurance purchased on their behalf, paying a very nominal fee for not having to purchase insurance at all. Presumably they get a little bit more money from their employer. And there they are, free. Personal liberty. Call it activity, call it inactivity, call it libertarianism, call it lack of paternalism, whatever you want to call it. They have more money in their pocket. They have more freedom with what they want to do with their money. And it's because of PPACA, not in spite of PPACA. Now, that's not a constitutional argument I've heard voiced yet. That, in fact, PPACA makes these people freer than before. But in large part, it's because the whole notion of freedom and autonomy and activity versus inactivity are not the kinds of questions that are useful if we're going to try to figure out how to solve our healthcare crisis, which is a significant problem. So I think the Supreme Court is going to find Jesus between now and March and say, Anti-Injunction Act, everybody go away. And I sure hope they do.
All right, well, thank you very much, Professor Richmond. I will not attempt to summarize those comments, though I sure would like to. Let me open it up to you folks, and I bet you have many questions, comments, concerns, plenty we haven't talked about, haven't addressed. Yes?
Curious about those exacerbations in PPACA you mentioned of the problem.
Oh, yeah. So if PPACA is successful, and what's funny about this is that the only reason PPACA would give people individual freedom is because it fails spectacularly in what it's trying to do. And the reason it would fail spectacularly is because the tax or penalties are not high enough. And if PPACA really wants to bring some order to the market for healthcare insurance, the penalties are too low. They would have to be a lot higher. Through binding us, we're set us free. I guess that would be the right metaphor. If PPACA to be successful and really try to organize the insurance market the way it intends to do, then it is building atop the current financing and delivery of healthcare, which is getting us into our mess. It will encourage individuals to take advantage of that tax exclusion that I mentioned. The tax exclusion, in addition to robbing individuals from lots of take-home pay, is also encouraging everyone to purchase more insurance than they need. And when people have more insurance than they need, and they consume more than they need, and if they consume more than they need, then there's a greater market for things that they don't need. There's a greater demand for new technologies that are more expensive that they don't need, but they now think they need because they can afford it. And we will see the healthcare sector going from 18% to 22 to 23 to 24%. Incidentally, in Massachusetts, we've kind of seen what will happen, which is, they've increased the number of insured there, which was the purpose, and that is good. It's very good, but healthcare expenditures there have increased dramatically. People are saying, well, we want a two-part solution to our healthcare crisis. First, we get everybody insured, and then we deal with costs. And it's easier to deal with costs once everyone's insured because then the cost problem becomes really, really severe as opposed to just a small emergency. And it's working. The logic is the faster you drive, the sooner you're going to get to the cliff. And we are getting the cliff faster.
I think Professor Richmond is right that most economists, healthcare policy experts would say that the exaction for non-insurance in the ACA is too low if your goal is to actually succeed in getting people to obtain insurance, right, to comply with the minimum coverage provision, avoid the shared responsibility payment. In Massachusetts, it's over $1,000 on average per person. With the ACA, after a few years, once it goes into effect, it's going to be about $695 or 2.5% of income for most people. That's not a whole lot of money, and it's clearly a political compromise, right? You have those who are advocating this statute, are concerned about criticism sounding in coercion, and so in trying to temper that criticism, they made it less coercive. Now, one of the constitutional ironies here, and you can tell that the panelists are coming at the problem from different perspectives, one of the constitutional ironies is that exactly what makes the so-called penalty, the exaction for non-insurance, vulnerable as a policy matter, I think makes it more defensible as a question of the tax power. Right? One of, I think, the primary reasons why this exaction falls within the scope of the tax power, notwithstanding the play other arguments have had, is because this exaction is predicted by the CBO to raise a significant amount of money each year, $4 billion. Now, query, why is it predicted to raise a significant amount of money this year? Because the exaction for most people to whom it applies is going to dampen their behavior, dampen the tendency to go without insurance. It's not going to prevent it. If it were much higher, imagine it were $10,000 per person. Imagine it were $20,000. Imagine there were criminal fines attached. It would clearly you would say that it's the Commerce Clause or nothing, or the Necessary and Proper Clause or nothing. It would be much less clear that it's a tax. But what's characteristic of taxes, at least in my own work on this, and what distinguishes it from regulations backed by penalties, is this distinction between dampening behavior and raising money on the one hand, taxes, and preventing behavior and therefore raising little or no money on the other, penalties. What the court's jurisprudence lacks is a persuasive analytical distinction between a tax and a penalty. Right? But I think if you buy the distinction I'm offering here and I'm doing in my own work, then the fact that the exaction is lower than it arguably ought to be makes it more defensible under the tax power. Other questions? Yes.
What do you think the constitutional implications of a single-payer healthcare system would be?
Depends how it's set up. I mean,
We already have one. It's called Medicare.
Yeah, it's called Medicare and Medicaid.
And look, maybe Steve thinks Medicare is unconstitutional. I mean, it certainly is. It certainly is helping us. It certainly is bringing us to that cliff.
Yeah, so I think under current doctrine, certainly, the government can very easily tax people a lot and then hire a lot of doctors and send them out to go give people medical services. It can also, under current doctrine, ban you from getting medical care from anyone who's not a government-approved doctor, except maybe in particularly unusual cases. I'm thinking things involving sort of abortion and contraception. There might be some issues there. But under current doctrine, I think that that's presumably how a single-payer plan would be set up. It would be set up as sort of the National Health Service and not as an obligation to sort of go to a private doctor, but you have to go to that one, and sort of nobody else can do it. I think it would be very hard to construct a sort of public-private merged single-payer system. I think they would just go all on the public side, and then it would really just be a tax power and a spending power and a couple of commerce issues.
Yeah, the way I would answer it is if Medicare is constitutional, and by the way, it clearly is under current doctrine, and it clearly is if you want to get confirmed to anything, right? Then Medicare for all is plainly constitutional, and another name for the single payer is Medicare for all, and that raises questions about what are we doing here, right? And why are we fighting? And invoking severe threats to the federal system when Congress does it this way as opposed to the other way, right? Congress did it this way in order to be responsive to concerns about coercion and autonomy, to give people choice. The ACA preserves private insurance markets. It lets people choose among the different options. Where does the individual mandate come from? Right? It comes from conservative Republican think tank folks, right, at the Heritage Foundation, members of Congress who offered an individual mandate as an alternative, as a more freedom-respecting, market-oriented alternative to the Clinton health care plan. right? Now we're told it's not only politically a bad idea, but unconstitutional to boot, right? So I think if, one of the other ironies here is what becomes politically possible or preferable is unconstitutional, right? And what is constitutional is rejected on political grounds.
Just to clarify, this is their field, not my field. My field makes a lot more sense than that.
Yeah, I think one thing that's interesting, actually, if I could jump in the state's brief on the merits, is that they make precisely this point. They say, look, it would have been a lot easier for everybody if we just passed a tax. They have their arguments as to why they think this isn't a tax. But they say that doesn't change the fact, though, that sometimes Congress doesn't take the sort of politically difficult road that it's actually allowed to do, but tries to do a shortcut. So when you force people to buy insurance, and you force them to buy insurance at rates that are higher than what's actuarially fair for you, you're a healthy person, you're never going to see this money back, because it's increased to account for people who are already sick. What you're really doing is just sort of a private form of taxation. You're sort of moving money from one pot to another, but it doesn't look like a tax because you're calling it a forced purchase. Sort of like the forced loans that the kings used to do to make sure we're not raising taxes, we're just requiring you to loan us money. They argue that is constitutionally forbidden, and there's a reason for that because it doesn't sort of pass the gauntlet that a tax measure goes through. And that if they're right that this isn't a tax, then there would be a worry about trying to do it through the back door.
Right, so what that would mean is that everything under the tax power turns on whether Congress uses the T word, right? It doesn't matter that nobody escaped political accountability, right, for doing this. It doesn't matter that so much is buried and suppressed and hidden in the tax code. Congress spends money all the time, right, by calling it a tax break. And good luck if you're a court who's going to start vindicating norms of accountability or running the gauntlet by starting to expose the federal budget to all those machinations, right? So I think this is a new argument, right? This is an argument that courts should be more robust in their review of measures that look like a tax in terms of their material characteristics, are predicted to have the effect of a tax, right? But that Congress didn't call a tax, Congress called a penalty. But called the people subject to it as taxpayers and made it part of your taxable income and put it in part of the Internal Revenue Code, right? So if you're going to make the whole argument turn on whether Congress used the T word, I think we're in for a different jurisprudence than we've had. Okay, other questions? Yes.
So if the court invalidated any part of this or the entire act, is there any political will or what's the feeling that Congress would, I would pretty much only assume it would be if Obama was reelected, that there would be at least something along those same lines that would be reconsidered, or, I don't know with the Republican Congress if that would work, but I guess what are your impressions of that, if they would try and change it? I don't know how the court would invalidate it anyway. I'm persuaded by the argument that they won't, but.
Could you tell us more about what Congress looks like after the 2012 elections? So you've told us Obama's reelected. What about Congress? Are there 60 Democratic votes in the Senate? Probably not, right? So you're going to have at least one House of Congress controlled by Republicans and probably not a filibuster-proof majority in the Senate, which means it's going to make any kind of legislation more difficult. The one scenario in which I see Congress overcoming the political polarization is if the court strikes down the minimum coverage provision, right, and leaves standing the guaranteed issue and community rating requirements. Because then you're going to have insurance companies who have a whole lot of clout in Congress going nuts. And Congress is going to have to do something. Now, another irony, since we're counting the ironies, is will striking down this law succeed in having Congress raise taxes? Right? Because Congress is going to need to do something. And there's not going to be the will to undo the whole statute. But if you have the minimum coverage provision struck down and you have insurance companies not being able to control costs, does Congress have to raise taxes or find some other way to subsidize the insurance companies, to do something to keep them financially inviolable without the mandate? So that's one scenario in which I see Congress overcoming the polarization. But in terms of getting together in other ways, I'm not optimistic.
We can actually add another irony to all this. The real levers of power, policymaking power, in the states, not in the federal government, as far as licensing laws, insurance regulation. And it is possible that states will start to be a little more creative and start addressing the problems. Another possibility, and just, maybe this would be helpful if there's a divided government, is that some more seriousness to the Simpson-Bowles recommendations will come, and there will be an effort to cap or maybe even eliminate the tax exclusion, and there'll be efforts to reform Medicare reimbursements, such, among other things, to make sure that readmissions aren't paid for. So hospitals, actually, by the way, this act was not written by a compromise between Families USA and the Heritage Act. It was written by a compromise between the American Hospital Association and the American Medical Association. And in that sense, those are really, it's those receivers of the federal dollars that really should start taking haircuts. And it's possible that that Medicare reform, just as far as just making sure that it's financially stable over the next 20 years, might start doing that also. I do think that the problem is so severe that even a remarkably self-interested and maniacally stupid Congress will still be able to do something about it.
I would say that my hope is that should there be some opportunity for reexamination of this, that Congress would look seriously at ways to really start fighting the healthcare cost problem. My fear is that they will do exactly what was done in the ACA and in other circumstances, and will focus more on efforts for spreading costs at first and reducing them later. You could definitely imagine situations where all the really popular parts of the ACA, if it's all struck down, come up for a revote. So make those bad insurance companies stop denying coverage based on, the fact that you have a lower risk or you have a higher risk profile than someone else, or prevent them from charging different rates to people based on their, risk profiles. If you do that and you don't have a mandate or you don't have some other way to compensate the insurance company for it, you're going to have real problems, because if you're going in for an operation tomorrow and you buy insurance today, it's really just free money from the insurance company. And no business can stay in business if that's the rules under which they operate.
Yes.
I think there's an obvious candidate for who's going to answer this, you. How might the government most effectively rebut Paul Clement's assertion that if the minimum coverage provision is a valid exercise of the Commerce Power, that the government can regulate virtually anything with the Commerce Power?
There are various ways in which it's not true, right? And that's the claim that's often made, that if Congress can do this, Congress can do anything. That's the claim that I think won United States against Lopez. At oral argument on Lopez, this was the Gun-Free School Zones Act case, in which Congress prohibited carrying a firearm within 1,000 feet of a school zone and then defined what a school zone was. Right? Several times at oral argument, the justices asked Solicitor General Drew Days, if this statute is constitutional, what is beyond the scope of the federal power? And he either couldn't or wouldn't answer the question, not once. Even Justice Ginsburg got into the act and asked him the question, and he couldn't, right? And it was strike one, strike two, strike three, you're done, right? And the lore in constitutional circles at the Justice Department is that the inability or refusal to tell the justices one federal law that was beyond the scope of the Commerce Power doomed the case. I don't know whether that's right, but it certainly couldn't have helped, right, not giving that. So the question is, if Congress signs off on the minimum coverage provision, is anything outside the scope of the Commerce Power? And it seems to me that you still have various limits. You have the Lopez and Morrison limits, right? You can't impose any and all mandates. You can't impose social mandates that would require people to possess a firearm in a school zone, possess a firearm at home. You couldn't require people under the enumerated powers to render assistance if you witness gender-motivated acts of violence being perpetrated in your midst. That's the facts of the United States against Morrison, where they struck down the Private Civil Damages Remedy, the Violence Against Women Act. Social mandates, requirements to do various stuff, as opposed to economic or financial mandates. Right? It still seems to me to be under Lopez and Morrison beyond the scope of the Commerce Power. Now, what about economic mandates? Right? Requirements to purchase various things. Right? One response, which is not going to be responsive to you and not responsive to the courts, but I think worth underscoring, is that whatever you think of the political safeguards of federalism in general, here is a case in which they are on steroids. If you haven't figured it out yet, these kinds of mandates are not popular. Right? And nobody, from the president to the Democrats in Congress, has escaped accountability for their unpopularity. So the idea that Congress is going to start routinely imposing economic mandates, no matter how unpopular, I'm more worried about other things. I'm more worried about, can the federal government respond to a flu pandemic that's disrespecting state borders? Can it mandate vaccination? And the answer is, of course it can. And if you don't think so, look at the oral argument transcript in U.S. against Comstock, in which Scalia and Kennedy are talking about federal quarantine authority being easy cases under the Commerce Clause. Right? So I do think political safeguards with respect to these kinds of mandates matter. Even if you don't buy the political safeguards argument, right, you have to have an economic mandate. Then in my own work, it's not just, you have to have an economic mandate that doesn't violate individual rights. Now, you might say, well, that's cheating. Of course, there's a distinction between powers and rights, except that those criticizing this law routinely disrespect the distinction between powers and rights, including certain federal judges. Right? A mandate to consume broccoli is going to violate substantive due process unless we're in an emergency situation in which the only way to cure people of the flu pandemic is to force them to eat broccoli. In that situation, the federal government can force you to eat broccoli. Otherwise, it would violate the right to bodily integrity. Right? So you've got no social mandates, no mandates that violate individual rights. In my own work, it's not just a question of whether or not the mandate is economic in nature, but the general form of regulation. Is it solving a collective action problem for the states? Are these problems that the states can deal with well on their own? Or are they problems in which the states can't? The court has captured this inarticulately by distinguishing economic activity that substantially affects interstate commerce from economic activity that doesn't. I think there's a real argument based on cost shifting and adverse selection that you've got a collective action problem for the states here, whereas you wouldn't in other kinds of circumstances. If those limits aren't enough, then something else I've suggested in my own work that no one has thought about because it sounds way too much explicitly like economic substantive due process, which is what I think these Commerce Clause challenges are, is something like a less restrictive means test. Right? If you're really concerned about economic mandates, notwithstanding that they respect rights and solve collective action problems for the states, right, I would suggest that you have a concern that sounds in something else other than the constitutional structure. But if you're still concerned about that, then query whether or not alternative means, something other than a mandate, would address the problem less coercively and about as effectively. And what I would suggest with respect to this law is you're not going to find anything. You'll find something more coercive, namely the single payer, Medicare for all. Right? I don't think courts want to go there because it sounds like substantive due process and it seems to fly in the face of McCulloch. If the end is within the scope of the Constitution, then the means, like a mandate or something else, should be up to Congress. That's been the tradition. Right? So I think if you reject that, maybe the problem is not with the means to limit federal power, but the objection to federal power to begin with.
Just an irony, shall we say, to the Clement question, is that the flip question I find is a much more compelling one. If Congress can't do this, can it do anything? And if it can't try to tinker with 18% of its GDP and try to forestall financial disaster, then what can it do? Now, not sure that this bill does that, but if this bill is unconstitutional, then surely that magical bill that will solve our problems will be unconstitutional as well.
But I do want to ask you about that Barack. It's hard for me to call you Professor Richmond or keep calling you that, because...
Call me the crazy guy on the end.
Right. That's, I will not. I will call you my friend Barack. Right, because, and I realize part of what you're saying is tongue-in-cheek, and I realize your basic point, which I think is really worth, which is why I invited him, frankly, is that we are so fixated on these constitutional questions. But in fact, if our problems are so much bigger, if the house is on fire and we're debating about whether you can force me to leave the living room, right, or whether I have to first be leaving the living room, the house is on fire, right, get out of the house. So I can understand why, right, that you're saying is that our problems are so much bigger, let's not be distracted. But nonetheless.
Well, actually, the better metaphor is whether or not it's okay to use this fire extinguisher, not leaving the house. But
okay.
Go ahead.
There you go.
We're trying to save the house.
It's my metaphor and you can't have it. But don't you think, even from a prudential policy, healthcare policy perspective, if the court strikes this down, right, might it be more difficult to come up with solutions in the future because of constitutional constraints? You might think that this statute is full of problems and it may not make it much better and it may make it a little worse, but if we start imposing constitutional limits, then good luck to us even more in the future. And I think there's an analogy to campaign finance here. You might think federal campaign finance law is a mess, right? But if the court's striking it down and doing it vigorously, then is that just a counsel of despair? There's really nothing that can be done because whatever can be done through our imperfect, ugly political process then gets struck down by the courts.
That's exactly right. What was it? What did Justice Scalia say when he was here? Well, yeah, that stamp.
Stupid but constitutional.
Stupid but constitutional. Fine, take out the stamp if you want to. But but it's true. If you remove whatever abilities there are to solve our nation's biggest problems, then our nation's biggest problems aren't going to get solved.
All right, Steve, do you want to speak to this?
Oh, sure. I mean, the only thing I'll say is just that there's a very long tradition in con law of saying that really, really important problems can't be solved through the means that the government chooses. I mean, a great example of this is the steel seizure cases. I mean, steel seizure cases came in a really scary time. The idea of having the nation's steel supply taken away was going to be a big problem, and they still said no. The president can't do it on its own. There's certain procedures there's certain actors who have to be the first movers here, even if it would be better for the president to be able to do it. And they said no. Federalism can be the same way. There's no guarantee in the Constitution that the federal power will always be adequate to achieve good things. And who knows, it may not be.
All right, well, last question.
Let's see if I understand. I'm not a lawyer. Let's see if I understand this correctly. You have been defining an entire system that's based on a federal problem. No question that the states have the right to make an individual mandate. Massachusetts law is constitutional.
Yeah, the only way the states would not have the right is if there was some individual right, like substantive due process.
Then you have stated that it is conceivable, probably not even improbable, that the court would rule the individual mandate is beyond the power of Congress.
I think it's certainly conceivable. I think my own view is it's more likely than not that if they reach it, they'll uphold it.
But then you have said that you believe that it would be perfectly reasonable to believe that Congress has the power to require that everyone be insured, probably under the Commerce Clause. Okay. If that is the case, it does not destroy insurance companies. It raises the price of insurance. That's all it does. In which case, there will be a whole lot more uninsured people. Mm-hmm. And the states will be faced then with a mandate of tons of uninsured people with a federal requirement that the price of insurance be enormous. Don't you think it's likely that the states will respond with their populations having vast numbers of uninsured people now that probably within their own laws have to be dealt with at public hospitals?
I'm not sure I follow the logic that got you to where you are, because I think if the court strikes down the mandate and upholds the provisions that require that disallow insurance companies from controlling costs, it seems to me the insurance companies, right, are not going to be able to make those distinctions, right? And so I think the insurance companies are not just going to raise costs; they're going to be in financial trouble.
They raise the price of insurance for everyone who is willing to buy it, because then they have to cover people who don't have insurance, but they have to pay. But they'll raise the cost of insurance. Obviously, people who are sick will buy it.
Right.
The people who are not sick many of them, probably most of them, will still want insurance.
Okay.
But the price will be much higher.
Right, so you're saying there's no discrimination, it's still guaranteed issue and community rating, it's just going to be...
Destroy in principle in the private insurance system. You may practice to it, but in principle you don't. In which case, many people will not buy the insurance because it's simply too high for them to pay. And
So then the question is, won't the states pick up the mantle?
not likely respond with then their own mandates, which would be constitutional.
The states that by law have to have balanced budgets and that are under severe financial pressure, states like Texas and California that have many millions of uninsured people already, and there's been no political will to do much about it. I think you'll have some states taking some action, some states being opposed in principle, and some states being imposed in practice because of the financial circumstances in which they find themselves.
But in principle, you're saying the federal government has the right to pass a mandate.
Has the power, I would say.
Could dramatically increase the cost to states, and frequently does. And the states then would have to respond with perhaps a law that would possibly be unconstitutional federally, but would be constitutional for them.
Yeah, not sure I understand myself to be saying that. But let's stop it. Let's stop it there. Thank you all very much for coming, and thank you to my colleagues as well for their participation today.
Produced by Duke University. Online at duke.edu.